Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to deviate a little bit from the Second Amendment. We're going to talk about the Fourth Amendment, our protections against unlawful and unconstitutional searches and seizures. But we're going to circle back and explain why this case that we're about to talk about is huge, especially if you're a lawful and responsible gun owner. We'll connect all the dots for you in just a moment. So today, let's spend a few minutes and let's talk about how this search and seizure case will affect your gun rights. Okay, America, as you know, sometimes I just spend my evenings going through the Supreme Court, reading Amicus briefs, taking a look at cases, and every now and then you just decide to look at a case that has nothing to do with the subject matter that we normally cover here at Washington Gun Law, but then you realize it has everything to do with it. And that's the case we're going to be talking about today. The case is called Case v. Montana. Now, this is not some case that might make it to the United States Supreme Court. This is a case that not only has already made it to the United States Supreme Court, they just had oral arguments on it on October 15th. So, America, there is a ruling coming on this case, and this ruling, listen here carefully, is going to be immensely important if you value privacy inside your own home. Now, this is a Fourth Amendment case, so let's just go over the text of the Fourth Amendment one time so we're clear on that. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, so if we go to our levels of proof right here, you will see that searches and seizures theoretically must be supported by at least probable cause. But is that true? The answer is no, it's not. No, it's not even remotely close to being true, because over a couple of hundred years of case law has whittled away and made all sorts of exceptions to that. Now, we could do a whole video series about just Fourth Amendment case law. But in general, there are exceptions to do you need probable cause to effectuate a search or a seizure on an individual? Well, in some instances, you don't. In some instances, you need less than probable cause. Some instances, you don't need anything at all other than where they're at or who you are. Some of the more common exceptions include consent, hot pursuit, incident to lawful arrest, vehicles to some degree, but vessels for sure, exigent circumstances, which we're going to be talking about today, border patrol, and then you have some limited types of search requiring some levels of proof, such as a Terry pat-down, which only needs a reasonable and articulable suspicion, or the community caretaking or emergency function, which we will also be talking about today. Every one of these, with the exception of a couple, requires some quantum of proof. That is, the government must offer some evidence to justify the intrusion into a person's private affairs. That standard is based traditionally on what is our expectation of privacy. So when we are out in the public, or when we are out driving a vehicle, which theoretically actually puts us out in the public as well, many courts have said that actually the only standard of proof necessary to effectuate a search or a seizure in limited degrees is a reasonable and articulable suspicion. But when it comes to our home has always been our castle, and the standard forever has always been probable cause. Officers must be able to articulate something rising to the level of probable cause of criminal activity in order to forcefully enter their way into a home. Okay, you got all of that? Now, here's the facts of this case. September 27, 2021. Case's ex-girlfriend calls law enforcement and says, oh, I think he might be suicidal. And oh, by the way, if the police go there, he might want to commit acts of violence against the police. 4 officers decide to go to the home anyways, and these 4 officers are actually already familiar with Mr. Case, and yes, they are familiar that he does have a history of mental health issues. They ultimately, as they're sitting there for 40 minutes, of which during time, if they had probable cause for criminal activity, could have obtained a warrant, they decide that really he's probably not a threat to anybody as long as officers don't forcefully just enter their way into the home. So, of course, after that 40-minute discussion, officers officers decide to go ahead and forcefully enter their way into the home, which results in Mr. Case being shot, fortunately not killed, and during a search incident to them entering the home and shooting Mr. Case, they find a firearm. Mr. Case is ultimately charged on several counts and files a pretrial motion to suppress the firearm, saying, should have never been discovered. It's fruit of the poisonous tree because they unlawfully entered my home. They did not have probable cause. The Montana Supreme Court, however, by a vote of 4-3 says, doesn't matter if they don't have probable cause. They don't need probable cause. Now, that comes as a big shock to everyone, including the petitioners on this case. It may explain why the United States Supreme Court has decided to take this case, is because this is in direct violation of a case from 2021 called Caniglia v. Strom, which basically said, hey, listen, you're going to need probable cause. You can't just have a reasonable suspicion of an emergency to forcefully enter a home. So the court declined to do exactly what the Montana State Supreme Court has done. But the Montana State Supreme Court has actually made it a little bit more dangerous because they came up with a whole new standard called reasonable exigency. Now, we're going to focus on an amicus brief that was filed by all of these Second Amendment organizations right here on this case, because these organizations could foresee the problem that this standard could create. The amicus parties specifically pointed out that there is a massive problem if this reasonable exigency standard is allowed to stand for forcible entries into home, and it goes like this. First, it posits that the officer has a duty to act overriding the Fourth Amendment's protection of the home. Second, it allows a forcible entry into a home whenever a citizen may be in peril, which requires little or nothing more than a possibility, allowing it to be met without much difficulty. And third, it allows forcible entry into a home whenever a citizen may need some type of assistance from an officer. Again, this requires little or nothing more than a possibility of needing some type of assistance. And this would actually be bad public policy, especially when it comes to safety. Not only safety of the homeowner, but safety of the officers as well. And the amicus party wisely points out, remember, in neither of these situations has the citizen sought help, for that almost certainly would constitute consent. In both of these situations, the entry is against the will of the homeowner, causing risk to both the homeowner and the police. But the big problem is summed up this way. In truth, there are no standards at all to apply to a forcible entry. In every situation, the actions of the police are justified and the rights of the citizen are compromised. And when you think about it, if they want to force their way into a home because they believe that there is criminal activity actually occurring there, they actually still need to establish probable cause. And if they want to go search the home, they're actually going to need a warrant to go do that. But when we come to an emergency standard, well, then suddenly the standard gets much lower, which of course leads the amicus party to ironically point out, what makes this special Montana rule so curious is that it actually gives criminals greater rights than law-abiding persons to the integrity of their homes. So America, this is why this is so important, especially if you live in one of these civilian disarmament states, or if we ever have another administration and an ATF that's hell-bent on disarming American citizens. Because we could think of all of the allegations that could be made against lawful and responsible gun owners. And since those allegations wouldn't be sifted through by a court of law in which both sides could explore the weight of that evidence, it would be based merely on a reasonable emergency in which any officer, all they have to do is act somewhat reasonably. Well, they could force entry into the home for lots of reasons, including seizure of firearms. And in many ways, a forcible entry into a home to seize firearms for many firearm owners is in fact the doomsday scenario. It would obviously place both homeowners and law enforcement in horrifically dangerous positions and would ultimately lead to less safe communities. So America, I want you to understand that your Second Amendment rights can also be eroded through the erosion of other constitutional rights. And the Fourth Amendment is a right that protects you from unreasonable government searches and seizures. And could you think of any constitutional right as important as your Second Amendment right to preserve your right of self-preservation than the Fourth Amendment right to keep you free from unreasonable government searches and seizures. And that, America, is why the matter of Case v. Montana before the United States Supreme Court is one of the most important Fourth Amendment cases in a very long time, and one that will have a dramatic effect on your Second Amendment rights. Now, case was just argued on October 15th. We expect a ruling probably in May or June of 2026. Listen, we're going to go ahead and link up everything we relied upon in making the video down below in the description box, so you don't have to take our word for it. You can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the information on how to do that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.